Our next speaker is Bing Wang. He's a professor and vice dean of Tsinghua University in Beijing. He's the director of Research Center on IP laws. And
how to close this one?
If we can get it going, he's going to give us the perspective on Chinese law towards GUIs.
Good afternoon, everyone. First, I would like to thank Professor Janice and Dinwiddie to invite me to be here to learn a lot from speakers and some participants. Second, I think it's my honor to here to make presentation. As you know, most of you know, China at this time does not protect the GUI as the design patent according to patent law and its examination guideline for patent examination. Yeah, but actually at this time in the Chinese academic society and also in industry, some people begin to think, should China protect this kind of GTI as the design patent or issue special regulation to protect them as the design right or take any other way to protect them. And actually our group has conducted the research product. We collected all relevant material as possible as we can and read it carefully and think about this issue. So my presentation actually is my understanding of this issue. I try to understand, to know fully the actual situation in many countries such as US and European countries and Japan. And also I want to try understanding correct the situation. So then we will think about should China protect this GUI and then how to protect us strategically, yeah, and then make everything more detailed. So in my mind, first thing I would like to think that the reasonableness of intellectual property protection of graphical user interface of electronic products. So I think that the GUI has this kind of basic technological features. GUIs are actually the result of react of electrical current with the material of displaying performs, such as computer displaying green, modified green, something like that. So which is different from traditional works and traditional design. GUIs are controlled at real time by relevant hardware or software or their combination, mainly at this time by computer software. GUI could be static state and also could be movable. Just the Mr. from the United States give our several examples. Yeah, so it can be movable, and also could be appearing or disappearing on the screen. Can those work well? Oh, another continue. Oh, next one. They could be two dimensions and also be stereoscopic. Second one, if consider from the IP protection, I think there are some basic intellectual property features. It is kind of expression of human ideal and emotion, just like the works and the other kind of design. And also it is aesthetic and all decorative. It has some, at the same time, some function which is different from traditional works. And also digitalized works. It has commercial value, of course. So therefore, in my mind, it should be protected. Yeah. And then look at the detailed intellectual property feature of GUI. It is real-time expression while electrical current react with the material of displaying screen. So in this point, it is similar with digital express of works when works is digitalized. Almost same. Use the color, number, letter, and figure, something like that. Almost same. It has its aesthetic content. It is incorporated in industrial products, which is different generally from the works or digitalized works. Huh? Okay, again.
Well, the value of teaching is repetition.
Yeah, it's some problem. It cannot be separated from relevant hardware or software or their combination. I mean that because they are controlled at the same time by this kind of thing. So therefore, in this meaning, it cannot be separated, but it can be separated from the relevant display, the screen. For example, sometimes it is displayed, disappeared on the screen. So if you look at the protection way in major countries like USA, Japan, and European countries, there are generally here three kind of way to protect. Yeah. The first way is that GUI is protected under the patent law as the industrial design patent, and protected also in some cases under the copyright law and trademark law. This is US way. Yeah. I would like to repeat it again because a lot of several speakers from USA talk about this. So under this design patent protection system, some GUI can be protected by patent law as the design patent, and others will be protected by copyright law or trademark law. Because according to US patent law, a substantial requirement for granting patent is almost the same as the substantial requirement for granting patent for invention. So therefore, only some GUI can be protected as the design patent. And then looks European way. Under the European relevant regulation, the definition of design, including GUI, is wider than USA. So under this system, I think almost all GUI are put into the protection under this regulation as the design rights, not patent rights, design rights. Let me go here. And Japan, I think actually it's located in the middle way between USA and the European countries. So definition of GUI almost same as USA, but substantial requirement and also some restriction are given to the protection. So at this time, in my mind, I think there are still a lot of difficulties to coordinate those three protection ways. Don't know what. So since GUI is very complicated subject, so therefore you can put in them into the patent, and also you can put them into the copyright protection. Also sometimes you can put in the trademark protection. So therefore, at this time, I think there are no uniform system to give protection to GI. There are still some very difficulties to perfect all this kind of system. For example, in the morning, when the European country said German Supreme Court deal with the case in 2008, the unregistered design from China, created in China and then moved to European market. And then Supreme Court did not give protection for this kind of unregistered design. The reason is that the design is geophysical or something like that. But in my mind, it's not only unfair to deal with this issue, but also it has no legal background. Why Europeans give protection to unregistered design? Because the design actually is used, is marketed as the article. It not depends on the creation of this kind of design. So therefore, if some design was created outside of European country and then relevant article moved to European territory, this means this kind of design actually was used in this territory. So therefore, it also should be protected. This case shows us that there's still a lot of difficulties, a lot of conflict, theory idea to deal with this kind of protection. Thank you for your attention.